welcome to our first podcast here. We're so excited to have you, Felipe Alexander from AG Immigration, Alexandre Law Firm, and we are very excited to have our guest, Lory Rosenberg, who we've known for a few years. She's of counsel to our law firm. We're so honored to work with her and have her today in our podcast. So welcome, Lory.
Oh, thank you very much, Felipe. It's really exciting to be here.
Very awesome. Lory, tell the folks a little bit about you, about your career, about some of the things that you've been involved in, and we'll lead them to where we are now.
Okay, well, I started off many years ago as an immigration lawyer, and I've always practiced on the defense side, either helping someone stay in the United States or helping someone to get status in the United States. So in each case, I'm working with a person who is from another country and who needs certain legal procedures to work out in a positive way so they and their family can become part of the United States community. And so when I first left law school, I had worked in legal services and in some small private law firms. And I was working in Boston at the time. And there have been many, many changes since I started out. And so one thing I'll say about it is, because I've continued on the same path, more or less, for a number of years. And one thing that I will say about it is that every 5 years or so, I complain about how harsh and how strict and how difficult immigration law is becoming. And the problem is that each time I've complained about that, it's been unfortunately true.
It just gets worse and worse. So if you could go back to the first complaint, it's probably happened compared to now, right?
Right. Yes. Actually, it has. When I first started, there weren't even immigration judges in the system.
Wow. How did that work?
Well, they didn't quite know what to do, because in removal proceedings at that time, they were called deportation proceedings. There wasn't a judge. What happened was the officers who were naturalization examiners, I guess possibly they were the people who might have had a law degree or some experience with the law of immigration. So they were kind of recruited into being what was called special inquiry officers. And they conducted interviews in the same way that you might now bring your client into USCIS, and they would be interviewed by an officer. So that's how it started out. And
wow. So essentially, immigration court back in the day was like a USCIS interview.
Yes, pretty much. Pretty much. Yeah.
And did this person have to be a lawyer by trade, or was it essentially like an immigration officer today?
It was an immigration officer.
Wow.
So they're like an asylum officer that you might find in that situation. Yeah. And the thing is, at that time, our asylum laws basically did not exist. If you think about it, the Refugee Act of 1980 happened in 1980. So before 1980, what did we do? Well, we had some protections that came through the convention, the Refugee Convention, which is an international treaty. But we weren't required at that time to have the statute that we now have today. So we had basically untrained officials making those decisions as well.
Wow.
And then as things developed and we started having more and more asylum hearings in the context of removal, it became quite obvious that we could not really just continue with these officers filling in as judges. So things got much more professionalized over the years. And perhaps that's why they seem a bit more strict, because we have more rules and strict procedures and that sort of thing. I ended up actually getting into the system years later. After I first began as a private attorney and a legal services attorney, I then moved to Washington, D.C., and I worked for the American Immigration Lawyers Association and was the director of a program in their not the association itself, but their foundation. And in that capacity, we attempted to do advocacy and litigation with what is now DHS. It was then called the INS, Immigration and Naturalization Service. So, as things developed, and of course, as immigration increased in terms of numbers, in Washington, I got close to some of the officers and officials who were working here. And I say here, I don't really mean here, who were working there as adjudicators of cases. And so eventually, when a spot opened up on the Board of Immigration Appeals, I was encouraged to apply for it. And I did apply for it in 1995. And I joined the Board of Immigration Appeals as an appellate immigration judge. And
so tell us about the Board of Immigration Appeals. What is it? Yeah.
Okay. The Board of Immigration Appeals is an entity. It actually physically is located in Northern Virginia, not in DC, but Northern Virginia. And it actually is located in kind of a strip mall. So there's a large building attached to a strip mall. And when you go into the mall, there's, your typical movies and ice cream stores and so on, dollar stores. And then you go up in this building to the Board of Immigration Appeals on the 26th floor, perhaps on the 24th floor as well. So the board is a really strange creature. What happens at the board is very different than what happens in a typical immigration judge's court. In a typical immigration judge's court, you would go in and it looks much more like Perry Mason or Judge Judy or something like that.
Yeah.
At the board, most of the work is done on paper, and we never saw the people appealing, except in rare cases when the board would hold oral argument. And in that case, then you did see what looked like a courtroom with the benches for judges and so on. The board has its own set of rules, and theoretically, the board is an objective, impartial body. But think about it. It's connected to the Department of Homeland Security. Not that it's part of the Department of Homeland Security, but the attorneys working for the DHS are often people who have served in the immigration and naturalization system, and they know all the people at the board. They may have conducted hearings in trial court in immigration, and there's a very, I would say, kind of a good old boy feeling there. We're all part of the department. And instead of being an impartial immigration judge hearing appeals, you get the feeling that you're part of this one big system. And it is one big system. It's a system governed by Congress. And there's a lot of sensitivity at the board about not getting Congress angry.
And some might feel that making Congress angry would be perhaps reversing too many cases. I don't know.
Yes, of course. Yeah, you got it right on the nose. Yes, absolutely. And the thing about the board is I went there planning on being impartial, and I think I was impartial while I was there, but I was one of the few people there who had ever practiced outside of the government. And you know how it is, excuse me, with individual clients. If you have served individual clients and accompanied them to court, you know how nervous they can be, how scared they can be. You know how many are traumatized. Many just aren't ready to function normally in the courthouse atmosphere that exists.
Of course.
So, if you're one of those people, then you might have had clients, for example, where the client doesn't show up for their appointment on time. Why? Not because they don't think it's important. It's because they're afraid. It's like when you have to go to the doctor and you think, oh, I'm going to get some bad news. That's that feeling. You don't really want to go. You want to cancel and reschedule your appointment. That's how a lot of clients feel. So I was all aware of that, but many of the other people at the board were not. And I would sit around in meetings and have to listen to my colleagues say things like, well, if they really were respecting this process, if they really thought it was important in their life, they would have been here on time. I know I would have been here on time. They're thinking, right?
Yeah.
They just don't get it. I think that, a lot of us who have experience with the life-changing events that can happen when you're an immigration client, it just doesn't translate to these government officials.
So that's the importance of diversity of backgrounds, right? And
Absolutely.
I think maybe it's better now than when you were practicing there, but I'm not sure.
Well, okay. I think that maybe the consciousness, it's been about 20 years since I was there. So I think the consciousness in society in general has expanded and grown. For example, there was no gay marriage when I was there, right? And that's that requires whoever is adjudicating a gay marriage case to be open-minded enough to understand and accept that relationship. Right. So that did not exist when I was there.
Correct.
But at the same time, because of the Trump administration and the sort of challenging and adverse effects that happened in terms of immigration policy, now we have people at the Board of Immigration Appeals who are very enforcement oriented, I'm afraid.
Right.
And,
it doesn't seem that Garland is stepping up to kind of really revamp the system. This is the chance to really put in some advocates in there.
Right. Yeah. But he may also be, I don't know his full background, but I know he came from a federal court of appeals, I believe, in Washington. So he may not have had that much experience with clients per se, other than the government as his client.
Yeah, true.
And the thing is, when you think about other areas of law, one of the reasons we love immigration law is because we're dealing with human beings and their lives and their futures. And it requires a great degree of respect and care and empathy and compassion. Absolutely. And if you haven't had to develop that in your practice, like I know you have in AG immigration, then for Garland, it could be, as foreign as, well, we're dealing with numbers, we're dealing with statistics, we're dealing with other factors that are really more concerns that you develop when you're on the inside. That's right. One of the things I wanted to mention too, is that what was so valuable for me about being there, even though I often found it frustrating, what was so valuable is that I learned a perspective that I would not have been exposed to if I had never been in a government position.
Right.
It resulted in me writing a lot of dissenting opinions while I was there. And I actually feel very proud of having done that.
And we've quoted many of your opinions in our brief, so thank you.
Oh, well, thank you.
Yeah.
What really means a lot to me is that not just did private practitioners quote me in their briefs, but many courts have, including the Supreme Court. And
very nice.
That's been something I've been very proud of and very glad that I was able to get a dissenting message out to the public and to the courts.
Your word will live forever. Yeah,
I hope so.
that's really awesome.
I would love to see us persuade the powers that be to adopt more of my thinking.
Yes.
So hopefully we'll be able to do that together in the future.
Hey, we will keep swinging. And I always remind the staff and even the clients, the importance of having this compassionate viewpoint when defending these cases and convincing the adjudicator that this is somebody's life and this is a family. So Lory, just kind of picking your brain a little bit, maybe the folks here, they're wondering procedurally, how does it work? I know, I filed the notice of appeal and then eventually I write a brief. who does that first brief go to? Does it go to a clerk? Does it go to a panel? Who makes
Okay.
the final decision?
Okay.
Yeah.
Well, let me just describe to you a picture of the Board of Immigration Appeals. There are approximately 21 board members, or now they're called appellate immigration judges. And then, unlike a regular court, a real court, I call it, unlike a real court, the board judges do not have law clerks. Like, for example,
Wow. Okay.
people who've been recently listening to the news, let's say about the Supreme Court leak, there's been a lot of discussion saying they did an investigation and they talked to the judge's clerks to see if so on. In a normal court, you have clerks, and those clerks screen the cases for you. They may write a memo for you. They may do some research. They may even help the judges with some arguments or some creative angles, or the judge may be able to say to them, I'm interested in pursuing X, and the law clerk will go off and take care of that so that the judge can then have a better perspective to pattern her decision from. Okay, well, at the board, we didn't have clerks, and they still don't have clerks.
That's
What
incredible.
we have instead is, I don't mean this in a demeaning way, but it's somewhat like a secretarial pool. There's a pool of attorneys, very bright attorneys. They're all law graduates. Many are in the honors program. Many have been there for years. And the good news about that is they have an active and fairly accurate knowledge and understanding of the immigration laws, so that they're familiar with all the circuit court cases, all the Board of Immigration Appeals precedents, and that's great. What isn't so great is the way that system works. When you file a notice of appeal to the board, it goes to the clerk's office, and then they go through the processes that they follow to, in most removal cases, they order a transcript so that we can get a written copy of what went on in the hearing. And they send that, they make up a record of appeal, and they send that to you or to me now. And then they send a briefing schedule. So when we have that information, we can, write out and file our brief. And the important thing about the board is right now, and this has been this way for some time, they will allow one extension of the 3-week period that you get to brief your case. And so that's good. You know that at least. Now, when you finish your brief and you file it, first of all, the Board of Immigration Appeals is super strict about meeting deadlines, both for the notice of appeal and for maybe a little bit less strict for the brief. But you must meet those deadlines. And that means the date they give you is the date that the document, the notice or the brief must be received. And assuming that you do everything right and it gets there on time, what happens? It goes to this large pool of attorneys. I don't know the number exactly right now. When I was there and there was a slightly smaller board, we had over 100 attorneys, maybe 150 attorneys who were writing for the board members or appellate immigration judges.
So there is somebody writing for them to start off.
Absolutely. Now, that's great that there's some help because the numbers are voluminous. But at the same time, what is missing is deliberation. You expect when you have a panel of judges, or even when you have one judge, what helps you reach an honest and fair and reasonable decision is the opportunity for deliberation. You don't just, it isn't just like a yes for this kind, no for that kind, and it shouldn't be that way. It should be one where all the important factors are taken into consideration.
So given this volume and really the overwhelming task of trying to do a thorough job with the number of cases, what are some tips that people should use, when writing their briefs? How do we make it stand out, but maybe make their jobs easier? How do you reconcile those two?
Right. Well, that's a really important question, because if you provide a good perspective for the they're called attorney advisors, these law clerks, not really law clerks, but lawyers and others who prepare the decisions. They prepare them without first conferring with the appellate immigration judge or the board member. So, except in rare cases, like if a case has been designated for an oral argument, which is very, very rare, you don't sit down with that other attorney who's going to help you. That attorney is charged with a somewhat challenging task of drafting the decision without talking to the board member appellate immigration judge.
Do they at least know the adjudication patterns of the judge that they're working for?
Yes,
At least,
yes,
okay,
they're supposed to.
Okay.
So that's right. Okay, first of all, the main guide in deciding appellate cases at the board is the board's library of precedent decisions.
Mhm.
So any decision that's written in your case today has to comport with the existing precedent decisions, unless the board members are going to en banc, meaning everybody involved, or approved or written en banc, going to like overturn a decision and issue a new precedent. Then you wouldn't follow that. But in most cases, everything has to be consistent. And if it isn't, now I'm in this group, those of us out there challenging immigration judge decisions are going to go to the board. And if the board does not follow the law, then we're going to go to the Circuit Court of Appeals.
Of course.
Right? So what happens is, though, that's a little bit troubling to me, is that instead of conferring with the judges or board members, the staff, the attorney advisors, is charged with writing up not just draft decisions, but final decisions. They circulate them to the board members or appellate immigration judges on buff paper, all ready to go out to you, the counsel, or to a pro se appellant. And all that's missing is a judge's signature.
So
right?
the appellate judge technically has the authority to say, no, I'm sending this back, do it over. But in reality, bam, 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 we have so many cases.
Absolutely.
This sounds good.
And not only that, don't forget the way that the attorney advisors or the staff furthers their career is production. How many of these decisions do you send around to the judges in a quarter or annually? Who does the most? And when I was at the board, this was a bit troubling to me, but those attorneys who did the most in terms of production, who turned out the volumes of final decisions, got perks. Like they might get, first of all, they would get acknowledged in front of their peers. They would get maybe a couple extra vacation days or some sort of a prize.
A lifetime Costco membership,
Right. So it's not, it's troubling. Now, there are things that attorneys can do. And when I work with attorneys, I try to tell them that what you really want to do is, like you said, take into account how busy and how overwhelming the volume and the backlog is. So when you write your brief, what you want to do is write a brief not telling the staff or the board member what they already know, not necessarily quoting from a Supreme Court case that everybody knows, like the case of INS versus Cardozo Fonseca, which is a famous asylum case from the Supreme Court. But you don't need to tell them about that unless you feel like they have overlooked something in the past. And then, of course, you want to emphasize it. But for the most part, what you want to do is write a brief that the staff member can adopt most easily. You want to try to be non-controversial to the extent that you know you're sort of roped in by the state of the law. I would never discourage anybody from making a novel argument or attempting to make new law in their brief. I'm not saying that at all, but to the extent that you write in the way that the staff attorney could adopt your argument without causing too much of a chaotic response, the better you are, and they will hopefully adopt your argument. If you write it out clearly, it helps them not have to do that much work themselves. If you point out, this is the controlling case in this circuit, or here's a board precedent, following that board precedent, we must conclude that blah, blah, blah. And doing that in a way where, when you're sensitive to the way the board writes its decisions, is really important. And so you really need to be very experienced, I believe, as an attorney to take appeals to the board. You have to know the law. You have to understand the statute. You have to understand not just the board's rules, but the rules that you're going to face if you have to take your case further. You need to know, how's this going to be handled by somebody at a higher court level.
So, this is what shocks me, because I know the amount of work that goes into, I know the complexity of this work. And then a client will say, well, yeah, but I had an attorney in Chinatown say they'll do it for $1,000. I'm like, oh my gosh, so, I think it's important that people know the complexity and really, I think the background that you bring and this inside knowledge is really invaluable.
Thank you. Yeah. Well, the thing is that one of the toughest situations is when you as an attorney sign on a new client who has been to prior counsel, either a prior attorney or a notary, or their brother-in-law told them how to do it. And now here they are, they've lost, and they have to take an appeal. Whether it's at the board or whether it's through USCIS at the AAO, the unit that USCIS runs. In either case, you have to be very sure that the counsel you have is following the laws, not making mistakes, understanding the cutting edge issues, and what's coming down the pike in terms of possible legislation and that sort of thing. It's very challenging.
It is, but fun and stimulating, and it's like a puzzle and trying to really figure it out. I think it's stimulating. So how did you end up with us, Lory? We're really lucky to have this relationship with you.
My gosh, yeah, it's wonderful. Well, let's see. You and I met several years ago when you were, I think you were just starting out in New York.
Yes, in 2015, I think we connected. Yeah.
And if I remember correctly, you were actually talking about opening up in Florida as well.
Yep.
Right?
Mm-hmm. Correct.
And so you weren't really at a point yet where I could be that helpful to you, but we did have some really good talks and we connected. And then we just kind of reconnected fairly recently. Yeah. And it's really been wonderful because you have really grown enormously and you have such a polished and professional staff and so many offices that it's just a pleasure and a thrill to be working with you.
Awesome. Likewise. It, just the timing and the chemistry, it had to happen when it happened. And I think we've been really done some great things with the team. The team has been blessed to have trainings directly from from you.
Thank you.
When I was getting mentored in Crimmigration by Joanne McCree, I think you've heard her name before. One of the books that I read was your book that you wrote with Dan Kesselbrenner. So it's an enormous pleasure to have you, and just I can't wait to see the kind of work that we're going to continue to do in the future.
Right, absolutely.
So I'm excited about.
We're going to share that information with our listeners, aren't we?
Absolutely, absolutely. So that's why they have to stay tuned, because on a very frequent basis now, we're going to have these podcasts, and we're going to have fun. There's so many cases we can talk about. There's so much policy, war stories, and I think they'll continue to be a fun dialogue, just like this one was.
Yes, absolutely.
Yeah.
Thank you for having me on. It's been great.
Absolutely, absolutely. So folks, stay tuned. We're going to have many conversations with Lory. Bring your questions, and if we get enough questions about an issue, we might just make a video on it. So thanks for tuning, and we'll see you next time. Bye.